Madam Chair, may I explain my vote? Members, this bill has been amended since we last saw it, but there's no improving upon a bill that imposes criminal sanctions against doctors who provide abortion as part of reproductive health care. This bill is just as dangerous today as the day it was first introduced. The decision to terminate a pregnancy pre-viability is an intensely personal one. I think you've heard that from several members on the floor today. Indeed, it's among the most personal decisions anyone can make. And it's for that reason that the Constitution leaves it to that person, to them and their doctor, their family members, and their spiritual advisor if they have one. The government should not be intruding in people's lives and demanding a say on this decision, but that is exactly what this bill does. A person's constitutional right to an abortion pre-viability is now subject to the intrusive eye of Big Brother. This bill criminalizes the practice of reproductive health care and the training of new reproductive health care professionals. At a time when we desperately need more healthcare professionals in this state in every field, especially in our rural areas, this bill will chase them away from Arizona. Why come to a state to practice medicine when the state legislature would turn you into a criminal for doing your job of providing healthcare? And yes, this is healthcare. Every year, 22,000 women die from unsafe abortions. We're talking not only the life of the women here, but also the life of their child if their effort to abort the child goes awry, which it most certainly does when they're doing this without oversight of the medical professionals. If this wasn't healthcare, why is it that the following organizations have all written to us, pleading with us to vote no on this bill? The Arizona Medical Association, the Arizona Osteopathic Association, the Arizona Academy of Family Physicians, the Arizona chapter of the American Academy of Pediatrics, and the Arizona section of the American College of Obstetricians and Gynecologists. Obstetricians and gynecologists. Yes, they spend most of their time trying to bring babies to life. But they too understand that abortion is part of the health care that they provide to women, and they strongly oppose this bill. But it gets worse. Let's just go through with some of the problems with this bill, not only in criminalizing healthcare, but also providing for broad liability of persons only, not even necessarily in the healthcare field. Section 1 of this bill takes the extraordinary step of bestowing personhood on an embryo the minute it is fertilized. Section 1 adds language to statute. The laws of this state shall be interpreted and construed to acknowledge, on behalf of an unborn child at every stage of development, all rights, privileges, and immunities available to other persons, citizens, and residents of this state, subject only to the Constitution of the U.S. and decisional interpretations of the U.S. Supreme Court. And under Arizona statute, an unborn child means the offspring of human beings from conception to birth. That's Arizona Revised Statute 36-2151. This is truly extraordinary. This provision will open up the potential for criminal liability, prosecutions for murder, manslaughter, dangerous crimes against children, liability for wrongful death to any person responsible for a woman's miscarriage. It doesn't matter that the person responsible does not know that the woman is pregnant. The woman herself may not even know she's pregnant because remember, an unborn child is the offspring of human beings from conception to birth. Now, the person responsible for a car accident, which causes a woman to miscarry, can now be subject to a charge for manslaughter or for a civil claim for damages for wrongful death, an entire lifetime of damages. And what about prenatal care by doctors and healthcare providers? Their negligence could similarly prompt civil or criminal liability. Can you imagine what this could do to malpractice insurance rates for healthcare professionals? Do we really want to do that? The personhood provision would have dramatic impacts upon the difficult issues for doctors right now with respect to post-viability abortions that may be sought to protect the life of the mother. The personhood amendment means that doctors may need to choose between saving the life of the mother or saving the life, the personhood of the fetus. But either way, they court disaster. Criminal liability for nothing less than murder. Do we really want to do that to our physicians and to the mothers in an already difficult time? And of course, if the Supreme Court does back off of Roe versus Wade and Planned Parenthood versus Casey, the effect of this personhood amendment is to outlaw pre-viability abortion altogether for any reason. The personhood provision constitutionalizes the prohibition against abortion and takes state law completely out of the picture. We, here in this legislature, will be irrelevant. But still, that's not all. As a result of the amendment attached during conference committee, the bill exempts from the personhood provision a person who performs in vitro fertilization procedures. Why is this exemption necessary? Well, it's necessary because during IVF, doctors routinely perform selective reduction, a process to abort an implanted embryo to maximize the chances of survival of other implanted embryos. IVF also routinely involves engaging in embryo pre-implantation genetic testing to test for genetic abnormalities in embryos during IVF, so that embryos will not be transferred to the woman's uterus to achieve a pregnancy. So what is the problem here? IVF is a method used by millions of people worldwide to create a family. I support IVF, as do many Arizonans. But the exception from the personhood definition is too narrow and could ensnare persons in this field to criminal liability. Who exactly have we exempted here? Under the bill, only the person who performs IVF is exempt from potential criminal and civil liability. What about the nurses, technicians, anesthesiologists, or what about the people who store the fertilized embryos? Can they take advantage of this exception? Just a week ago, the New York Times ran an article on a hospital that discovered a couple's embryos 20 years later. They had somehow been lost, but there was a concern that they had now been damaged in storage. Is the operator of those storage facilities now liable for murder or wrongful death? These are real situations that this bill fails to address. But even that is not all. As a result of this exemption for IVF, the bill now has a curious double standard. While it would seem that embryo pre-implantation genetic testing by IVF centers to eliminate embryos that carry a genetic abnormality is perfectly legal and indeed routine, a doctor who performs an abortion of a fetus with a genetic abnormality, because of that genetic abnormality, will be subject to a felony. This double standard, of course, has a class component. Who has recourse to IVF? Persons with means. Who may, as a result of criminalizing the abortion of a fetus with a genetic abnormality, be compelled to carry that child to term, even though they may not be able to care for that child or may not wish to have that child? That will be the woman without means. And again, that is still not all the problems with this bill. That is only Section 1. Let's go to Section 2. The biggest problem with Section 2 is, of course, that it violates a woman's constitutional right to terminate her pregnancy, pre-viability, entirely when she seeks to do so because of a genetic abnormality, by criminalizing the doctor's performance of that abortion. That's big enough. But in doing so, it places our doctors and healthcare professionals in an impossible position. And indeed, this was the rationale for the no vote by the senator from District 25 when we last voted on this bill. And with all due respect, his amendment that was attached during conference committee does not fix the very problems that he raised. First off, to perform an abortion, and as a result of the senator's amendment, the doctor would need to determine that the abortion is not being sought solely because of the fetus's genetic abnormality. But how is a doctor to make that determination? What if a patient tells one person that they want the abortion because of a genetic abnormality, but the same patient had told their doctor confidentially that it was because of something else, perhaps because the child was a product of rape or incest? The doctor knows that the abortion is not solely because of the genetic abnormality. But to prove this, they would need to reveal privileged communication subject to the doctor-patient privilege. The upshot may be that the woman will not be able to receive the abortion, even though the abortion would be legal under this bill. Do we really want to place doctors in this very difficult position? It's no business of theirs as to whether and why a woman is seeking an abortion. Second, the senator from District 25 also got an amendment onto the bill to exempt it from the prohibition, on abortion of fetus with a lethal fetal condition. This was also in an effort to provide more certainty to physicians. But again, the standard of what constitutes a lethal fetal condition does not defer to the judgment of the doctor, as it would were we to have included language that it was subject to the good faith medical judgment of the doctor. That language is not used. Instead, it is subject to a reasonable certainty standard. That is an objective standard of the reasonable person, and the doctor's determination can be overridden by the decision of a judge or a lay jury. I've discussed just the most obvious problems with the bill, problems that may tie up our healthcare providers and even ordinary citizens in criminal and civil liability in new and unexpected ways that will generate lawsuits at taxpayer expense. And for what? The personhood provisions seem to be included as part of a long shot to get the Supreme Court to overturn Roe versus Wade. But this goes against the majority of what Arizonans want. A 2020 public policy polling survey found that a strong majority, 76% of Arizona voters believe abortion should be legal and that the government should not prevent a woman from making that decision for herself. A large majority, 79%, also agree, with 63% in strong agreement, that any decision about pregnancy should be made by the woman with the support of people she loves and trusts. This bill is being touted as helping persons with disabilities. But as others have noted, this bill does nothing concrete to help families with children with special needs who are with us today or even born tomorrow. Providing more resources and support to those children and those families should be our focus, but it's clearly not in this bill. At every step, we've refused to care for mothers and their children after they're born. We refuse to fund dental care for pregnant women or fund child care or early education programs. But we sure seem happy to insert ourselves into a private medical decision that should be made between a woman and her doctor and her God. In summary, this bill is an expansive intrusion of the government into a decision that should be left private, the decision to terminate a pre-viability pregnancy, and will chill needed reproductive health care for persons and families in our state. For that reason, I'm a strong no on Senate Bill 1457.